Rufus B. Rodriguez and Maximo Rodriguez. Sir?
This last bill, 4721, prescribes a higher penalty imposed on those done in a calamity, pandemic, or epidemic, or within a state of calamity, because, you take advantage of the situation. And therefore, we request that the sentence should be elevated 1 degree higher by the judge having these cases, no? It just emphasizes that the need of a stronger law when it comes to a state of calamity in the country, a pandemic or epidemic, so that they will not take advantage of the situation. That's in the essence is the bill 4721, Your Honor, Chairman. Thank you.
Thank you, Congressman Maximo Rodriguez of Abamin Party List. I'd like to acknowledge the presence of Vice Chairperson Joseph Jojo Lara of the 3rd District of Cagayan and Representative Bernadette Barbes of the 2nd District of Surigao, also our Vice Chairperson. Okay, the COMSEC would like to acknowledge the presence also of additional guests.
Thank you, Mr. Chair. From the Department of the Interior and Local Government, Attorney David Rafael Monsalud, and from United Nations Office on Drugs and Crime, Ms. Sheila R. Marquez. Thank you. Thank you, Mr. Chair.
Thank you, COMSEC. We now go to House Bill number 910, an act creating anti-drug abuse councils in all provinces, cities, municipalities, and barangays throughout the country and providing funds therefor, authored by the Honorable Bernadette S. Barbes of the 2nd District of Surigao.
Good morning, Mr. Chair. For House Bill 910, an act creating anti-drug abuse councils throughout the country, I just want to stress that HB 910, this is a committee report filed in the last Congress and a product of extensive deliberations in the committee. The explanatory notes of House Bills numbers 910 serve as my sponsorship speech. Thank you, Mr. Chair.
Thank you, Congresswoman Barbers. For House Bill number 918, an act mandating incineration facilities including crematoriums to render free services for the prompt destruction of dangerous drugs seized during anti-illegal drug operations, also authored by the Honorable Barbers.
Just the same, let HB 910, this is also filed in the last Congress, and let the explanatory notes of the House Bill 918 serve as my sponsorship speech. Thank you, Mr. Chair.
Thank you, Congresswoman Barbers. And lastly, House Bill number 921, an act promoting the speedy disposition of drug cases by creating a special court to be known as the Dangerous Drugs Court in every city and province nationwide and appropriating funds therefor. Also by the Honorable Bernadette Barbers of the 2nd District of Surigao del Norte.
For House Bill number 921, an act promoting the speedy disposition of drug cases by creating a special court to be known as the Dangerous Drugs Court, serve as my sponsorship speech. Thank you, Mr. Chair.
Thank you, Congresswoman Barbers. Now move to House Bill number 371, an act strengthening the drug prevention and control, amending for the purpose Public Act 9165, known as the Comprehensive Dangerous Drugs Act of 2002, authored by the Honorable Richard Gomez of the 4th District of Leyte. House Bill number 371, sir.
Thank you, Mr. Chair. For House Bill 371, in the last Congress, we've taken this up, comprehensive drugs of 2002. We have taken this up extensively in the last Congress. And just like today, I was talking to Yusek Andres and Secretary Valenzuela. There are updates that needs to be taken up. So maybe we can make this part of our discussion to update the Dangerous Drugs Act of 2002. Thank you, Mr. Chairman.
Thank you, Representative Richard Gomez. Also for House Bill number 5468, an act mandating all local government units with seaports to establish and maintain canine teams for anti-drug enforcement. Also by the Honorable Richard Gomez of the 4th District of Leyte.
Thank you again, Mr. Chair, ladies and gentlemen, colleagues. House Bill number 5468, a measure that strengthens our fight against illegal drugs by empowering our local government units to secure one of the most vulnerable gateways of drug traffic in our country, which is our seaports. Despite our sustained national campaign against illegal drugs, the threat remains one of the most significant challenges to our national security, public health, and social stability. The illegal drug trade continues to inflict deep wounds on our society, eroding social order, fueling criminality, breaking apart families, and weakening our people's trust in public institutions. Our country's archipelagic nature, with thousands of kilometers of coastline and numerous entry points, gives way to unique vulnerabilities. Seaports in particular, Mr. Chair, have become high-risk areas for drug smuggling because of the sheer volume of goods that pass through these gateways every day and the complexity of maritime operations. While national law enforcement agencies guard major ports, smaller or municipal seaports remain underserved, and it is precisely these gaps that traffickers exploit. I know that very well. We have so much of that in our province in Leyte. Now, House Bill 5468 mandates all LGUs with seaports to establish and maintain their own canine teams specially trained for drug detection and interdiction, Mr. Chair. Drug sniffing dogs are amongst the most effective tools in modern anti-drug operations. These highly trained canine units can detect illegal substances concealed in cargo, vehicles, luggage, and even within modified compartments designed to evade human inspection. The presence of canine teams in our seaports will not only enhance our detection capabilities, but will also serve as a strong deterrent against drug traffickers who often exploit weak or unmonitored local ports. The local government units are the first line of defense in protecting their communities. When we empower our LGUs with the proper tools and training, we empower them to save lives, protect families, and keep illegal drugs from ever reaching our streets. Mr. Chair, by intercepting drugs at the very entry point, we protect our communities from the destructive effects of illegal drugs. This prevention in its most effective form. In view of the foregoing, Mr. Chair, I respectfully ask my colleagues for their full support for the approval of House Bill 5468. Daghang kayong salamat, Mr. Chair.
Salamat, Congressman Richard Gomez. For House Bill number 5092, authored by Representative Chino Almario.
Mr. Chair.
Congressman Lara.
Thank you, Mr. Chair. As a representation for Congressman Chino Miguel Almario, I do manifest for House Bill number 5092, an act establishing regional offices and provincial offices of the Philippine Drug Enforcement Agency, amending for the purpose Republic Act number 9165, otherwise known as the Comprehensive Dangerous Drugs Act of 2002, as amended and appropriating funds therefore. I manifest to adopt the explanatory note at his sponsorship speech, Mr. Chair.
Thank you, Congressman Lara. I'd like to acknowledge the presence of Representative King George Leandro Antonio Colliantes of the 3rd District of Batangas. Thank you, sir. Also, Director Cesar Solis of the Bucor and Dr. Adriano Subaan of the Department of Health. Sir, thank you. I would like to hear the comments of our resource persons on the bills amending portions or sections of RA 9165. May we now hear from DOJ, Yusek Andres, sir.
Thank you very much, Mr. Chairman. Before I go into the particular details with respect to the House bills, may I be allowed just to present a situationer that also prompted the Department of Justice to consult stakeholders in relation to the possible amendments to the dangerous drugs law?
Go ahead, sir.
Well, it is a known fact that in 2019, Iceland, a member of the United Nations, filed a resolution to put the Philippines under the Human Rights Watch of the UN. And this prompted the creation of the United Nations Joint Program for Human Rights. This program already ended in 2025. But the good aspect of the UNJP program is that we were able to tap the stakeholders involved in the UNJP program to develop policies that will be used moving forward, coming from our experience. And from the UNJP program, there were 6 subcommittees formed, and one of the subcommittees formed is a subcommittee on human rights-based approach to drug control. So we took advantage of the many stakeholders already organized under the UNJP program, and we formulated through the cooperation of the DOJ, the Dangerous Drugs Board, the United Nations Office of Drugs and Crime, all other UP Institute for Human Rights, a law reform and drug summit. This was conducted in 2024, and a multi-stakeholder consultation was done involving 11 regions and more than 400 stakeholders. And we wanted to share with this committee the findings, the evidence-based findings from the grassroots that would be very valuable for this committee to be informed of, so that we can craft policies based on evidence coming from the ground. So later on, if it is possible, we will ask for a technical working group so as not to bother the committee itself, but a technical working group to receive all of these insights coming from the Law Reform Drug Summit. And this is under the auspices of the UP Institute for Human Rights.
Okay, Yusek Andres, yung output ng summit nyo, does it have anything to do with any of the 11 bills that are pending before us? Yeah?
Yes, it covers practically all
Okay.
of the subject bills. And that is why I find it very important for the TWG to be able to receive these new inputs, because I believe this is the first time we had a very extensive multi-stakeholder consultation. When I say extensive, we involved the national government, we involved the local government units, we involved the academe, medical practitioners, those who are involved in rehabilitation program, we involved law enforcers, we involved civil society organizations, human rights groups, practically all the stakeholders. That is why every aspect of the bills presented will have an input coming from the drug summit. And I can shoot out a few of the comments right away based on the notes that I have taken on the sentiments coming from the ground on these proposed bills.
Go ahead, sir, please.
Again, let me just emphasize that in 2023, the Philippine government made representations to the United Nations High Commission on Human Rights and gave 4 commitments. First is the creation of the National Forensics Institute for accountability, because we need to increase our capacities on investigation involving crime, including drugs. So the National Forensics Institute is already on its way through an executive order issued by the President, and we are expecting the cooperation with the Australian government to make this possible soon. And in fact, we believe this will be forthcoming by 2027. A National Forensic Institute that is based in the University of the Philippines, Manila, under the auspices of the UP system, an independent, academic-driven institution that will allow training of Filipino doctors in forensics investigation, including forensics pathology, through our cooperation with Monash University of Australia, which is an authority in forensics investigation. The second commitment is the creation of the Special Committee on Human Rights Coordination. So the SCRHC is now the new entity that is doing the work of the United Nations Joint Program. So all of the aspects of the UNJP program are now subsumed under this new body created that involves the DOJ, the DILG, and even the Supreme Court to continue the advocacies from the UNJP program, including enlivening civic space, data gathering, and national reporting system on accountability. So all of these are being taken care of. The fourth is the Philippine Human Rights Plan, which we already accomplished last month, and we were able to submit already to the UN body, including the EU. And this has been the work also of the interagency on the Philippine Human Rights Plan. The last remaining commitment is the executive review of the drugs law. And that is why, since last year, we have been working on this, and we thought it prudent to make a multi-stakeholder wide consultation. And now we have completed the consultation, and we are ready to provide the inputs and insights from the multi-stakeholder consultation to the TWG at the soonest possible time. So if I may go to with the permission of our secretary from the Dangerous Drugs Board and my colleagues in the National Government Agency, we can give a few comments on the proposed bills.
Please do, sir.
With respect to House Bill 4710 on aliens involved in drug trafficking, we take note of this, but with the observation that the proposal is to institute even the death penalty for aliens. We take that into cognizance, but most of the feedback that we are getting from the ground is that the accountability on the drug control is not really based on the severity of the penalty, but the certainty of persons being held accountable. So if we have procedures that will ensure the accountability of people who are involved in drugs, the penalty would be a secondary. But raising the penalty will not be the deterrent on its own. It is the proficiency of the investigation, it is the effectiveness of the prosecution, and if I may say, based on the reforms of the Department of Justice that we have started since last year, we have elevated the threshold of evidence before a person can be charged in court in a criminal case. It is no longer probable cause. Previously, we had numerous, I would say, over prosecution where even without sufficient evidence, we have charged people in court. In the last administration, we had more than 75,000 people incarcerated based on drugs. But most of these cases were dismissed for lack of evidence because there was no case build-up done. The law enforcement agents were just satisfied with filing complaints, and that was the measure of their matrix of performance, but not the successful prosecution of each case. That's why we aligned our efforts with the PNP and the DALG that the correct measure, matrix of performance, should be effective prosecution, leading to a conviction in court, and not just the filing of cases. And I'm happy to report that based on this new system, we are now having after a case build-up, although we are filing 50% less cases, the success rate has risen from 39% to 93.9%. So this is something, to me, is a better situation where we are able to exact accountability. And I'm also happy to report that most of these cases are no longer undergoing protracted litigation. Because at the start of the filing of the case, we already have the complete evidence, and the accused normally accept a plea bargain, enter the plea bargain, and therefore you have a final judgment of conviction and no more protracted trial, and accountability is exacted. But hand in hand with that effort to enforce the law would be rehabilitation programs. And the primary reason we are coming to Congress for the amendment of the law is to put resources institutionalized in rehabilitation programs stretched in the local government units where the presence of government can be felt. And that will be part of the proposal that we will give later on.
Sir,
But with
Yusek,
respect to making a distinction,
sorry, before you proceed, sir, you mentioned that there was an increase in conviction.
yes, sir.
Tama ba? From 40-something% to
93.9.
93%, right? But did that also lead to the reduction in the number of cases filed before the courts?
Yes, I would say, I do not have the exact figure, but I would say that almost half of the cases, number of cases year on year, if you compare it, would be less. But that doesn't mean that we have, stopped prosecuting a case. It will take more time for us to do the case build-up. But rest assured that once we have sufficient evidence to prove all the elements of the crime, then we will proceed with the filing of the case. It might take a longer time pre-trial, and there is no detention yet for the accused. But once we are ready to file the case, then it is really trial ready and a solid case already.
Can you provide us with the numbers lang po?
Yes, we
later
will
on.
provide the statistics.
Yung ano
John.
lang, statistics on how many cases have been filed also.
We will
Because
provide
while we commend the increase in the conviction, we would also like to see how many cases have been filed.
Thank you, Your Honor.
Thank you, sir.
And also, with respect to aliens being charged, there is a normal concept in constitutional law we call equal protection of the laws, where a particular rule should be applied similarly. So, with respect to aliens, we will consider whether this distinction is germane to the purpose. And as correctly stated, there are comity or reciprocity considerations, meaning if the crime is punishable similarly in another country, we will adopt the same measure here in the Philippines in the spirit of comity and reciprocity. Now, on random drug testing, I'd like to point out that this is a matter that can be considered, but be informed of the Supreme Court decision earlier on a similar case where the Supreme Court said that it is unconstitutional to mandate to make it mandatory for drug testing even for public officials applying for elective or appointive officials, appointive positions. So if it is a random drug testing, this may be allowed subject to certain regulations. But again, we will put in the insights coming from the Drug Summit because this drug testing can be discriminatory and at the same time puts a certain stigma. And we will put it into proper context because in our program, we are also looking into the important angle of removing the stigma from for people approaching health and medical institutions and rehab centers for treatment. The new trust that we are trying to integrate here, not only the human rights-based approach, it is the public health approach, meaning we are treating drug dependence also as a health issue where interventions, medical interventions on the physiological aspect should also be integrated on top of the psychiatric aspects or mental health aspects of drug dependence. So these are two aspects that interventions, specific interventions, and tailor-made interventions is necessary. Now, on media as witnesses being excluded, House Bill 4718, we totally agree with this, that media people should now be excluded from participating in the inventory for two reasons. In the first place, the media people were put there for additional transparency with respect to inventory of drugs seized. Okay. But as you said, the primary purpose of media is just to cover it. So they were there for that moment, and they are not willing to spend time and devote a portion of their regular day to attend hearings, to attend proceedings of investigation, because it obstructs their performance of their duties as media personnel. So we agree with this, and we are supporting the exclusion. In the same manner, we are also supportive of the move to remove the members of the National Prosecution Service as part of the people taking part in the inventory. We have to have faith in our law enforcement agents to do the right thing, because this is again subject to the credibility of the presentation of evidence. We are falling short in some of the prosecution because of the technicalities on what we call the chain of custody rule. Because in the absence of one of the required witnesses in the taking of the inventory and even in the marking of evidence, the court has a technical reason to cause the dismissal of a case. We agree that this should be reviewed and possibly removed. On the higher penalty, if the offense 4721, higher penalty if the offense is done during calamities, yes, I think this is something that can be adopted, similar to other provisions of the revised penal code, where a penalty higher is imposed whenever this is done in a condition of calamity or state of emergency. On the destruction of drugs and rehabilitation centers, yes, this is for us to institutionalize our response with respect to destruction of drugs, so that there will be no middle time between the actual incident of arrest and the presentation of evidence in court. There will be no possibility that the drugs will be, taken out of custody, legal custody, and probably rediverted into the market. If they are immediately destroyed and marked and already accepted by the court as evidence based on the certification issued prior to the destruction. On the creation of dangerous drugs courts, I think the pronouncement of the Supreme Court is that there are already existing dangerous drugs courts, and all regional trial courts are courts of general jurisdiction, and it would be better to have all RTCs continue exercising jurisdiction over drugs cases without limiting it to particular courts. On the seaports and securing our waters from drug traffickers, this is a very appropriate measure, as in fact we are doing this with limited resources and with the help of the Philippine Navy and the Coast Guard and of course PIDEA, and we have had a lot of success. And we will report it later when PIDEA is called to submit its accomplishment report. We have been quite successful now in increasing the seizures or confiscations of dangerous drugs that are entering the country through the seaports and even through floating mechanisms in the West Philippine Sea and the eastern border. On the regional offices of PIDEA, we also have our comments, and we can provide this to support this measure when we are allowed to give in detail our comments through the technical working group. So unless there are other specific questions, I can respond. These are the things that I noted, Mr. Chairman.
Thank you, Yusek Address. Before we proceed, we would like to recognize the presence of Representative Jervil Jinky Beatrix Luistro of the 2nd District of Batangas, Mark Anthony Santos of the Lone District of Las Piñas, Carl Nicolas Cari of the 5th District of Leyte, and Jose Manuel Jokno of Akbayan. Thank you, sir, for coming.
Mr. Chair, you were asking earlier on the statistics, and we
Yes, sir.
already consulted the office. We have 79,457 drug cases filed in 2023, whereas in 2024, we only have 33,012.
Almost half.
So there's
Less
even
than half.
less than half.
Less than half.
But I should note that the conviction rate now is 94%.
Okay. Well, what happened to the other cases that were not filed, sir?
There are two possibilities. Either the matter is not supported by sufficient evidence, or we are continuing to do the case build-up. If this is a complex situation where we need to gather more evidence. But at times, the problem is the matter was not implemented properly, and in the inquest proceedings, it was not proper for a warrantless arrest. And that is causing the technicality that will possibly be the reason for the DOJ to dismiss the case without proceeding to the trial.
Itong case build-up na requirement, has it also not put a strain on the services of the National Prosecution Service? Meaning,
Maybe to
mas
put-
malaki na yung involvement nila prior to the filing, right?
that's correct.
Because they are actively involved in the case build-up. Pero are we manned enough ba? Do we have sufficient manpower to do this?
Mr. Chairman, the DOJ crafted a justice reform program that we started implementing in 2022, and it's continued to be implemented now. And the major part of our effort is capacity building of law enforcement agents and prosecutors. So the key here is not only the DOJ being trained as prosecutors, but the law enforcers being trained on the proper implementation of a warrantless arrest or the application of a search warrant. And this has now led to stronger cases being filed, although fewer, but stronger. But the LEAs, the law enforcement agents, are continuously being supported in terms of capacity building. That's why in our concept of Department Circular number 20, we call the case build-up policy, the prosecutors, hand in hand with the prosecutor, sit down and comment on the complaint filed by the LEAs. Unlike before, we just wait for the complaint of the law enforcement agents, and if it's not satisfactory, we do not take a hand and simply throw it away. But we believe that is not an effective investigation and prosecution. We believe that we are both in the executive branch, and we should be able to lead and guide the law enforcement agents to do proper investigation and secure evidence consistent with constitutional procedures. And we have been more effective now because of that direct coordination. And we are now augmenting the efforts of the LEA when we guide them, and they are asked to refile complaints with additional evidence.
Thank you, Yusek Andres. Now I'd like to hear from the Dangerous Drugs Board on the 11 bills.
Chairman, can I pose some questions?
Yeah, go ahead, sir.
Do you have data, Yusek Andres, on the percentage of alien being filed court, having cases in court? And in this case, for aliens or foreigners, how many percentage are those in the higher echelon? You mean the ones bringing drugs
I
arrested
do not
here?
have offhand,
Yes.
Mr. Chairman, the data.
What is the percentage of foreigners being filed court in cases here? And then classify on whether these are really the top echelons of those cartels or triads, as we say. Do we have data on that? In case wala, then we will be asked for that data.
I will try to get it as soon as possible, Mr. Chairman.
Thank you, Chairman.
Thank you, Kong Maxi. Dangerous Drugs Board, comments on the 11 bills filed?
Magandang umaga po sa inyong lahat, Committee Chair Jonathan Flores, the rest of the members of this committee, and our resource persons. The Dangerous Drugs Board consistently thanks the House Committee on Dangerous Drugs for prioritizing the legislative agenda to amend the current law, the Comprehensive Dangerous Drugs Act of 2002. Even during the previous Congresses, the Dangerous Drugs Board has shared the implementation experiences which can serve as a basis and evidences to enhance the law, expand its provisions and coverage, and improve the framework governing the anti-drug campaign of the government. With the President's new trust in implementing his administration's drug abuse prevention and control agenda, the Dangerous Drugs Board believes that the integration of public health approach and human rights-based approach in the law that governs the national anti-drug campaign is not just timely, but very essential. Now is the right timing to do that. The country's fight against illegal drugs should be multifaceted, combining prevention, especially early intervention and education among the youth, treatment, rehabilitation, reintegration, combined with aggressive law enforcement actions. Allow me, Your Honor, to also emphasize that in our manifestation of support to the passage of the amended Comprehensive Drugs Act of 2002, we also advocate the strengthening of institutional capacity and organizational development, particularly of the frontline agencies leading the government's fight against illegal drugs, such as, of course, the Dangerous Drugs Board, the PDEA, the Department of Health, the Department of Justice, the DSWD, the Philippine National Police, the NBI, the Bureau of Customs, among other agencies. When this committee succeeds in its goal to pass an amended Comprehensive Drugs Act, we hope to see effective implementers also succeeding in their fair share of commitment to address the drug problem at the community level. In broad strokes, Your Honor, given the present situation, drug affectation and drug use in the country, the Dangerous Drugs Board is pursuing the following initiatives in the fight against illegal drugs. One is prevention, education, and civic awareness initiatives. The second is ensuring that treatment must be available, accessible, attractive, and, very importantly, appropriate. We are also pursuing initiatives to expand the capacity and infrastructure of those delivering frontline services to fight drug addiction, especially on institutionalization of relapse prevention and aftercare. We are also pursuing and supporting the priorities, the initiatives to strengthen the capacity of PDEA and other law enforcement agencies. And Yusek Jesse has already expounded on this a while ago. We are fully supporting the initiatives being pursued under the drug policy and reform agenda that was convened last year. Those are the current initiatives of the Dangerous Drugs Board. Thank you, Mr. Chairman, Your Honor.
Thank you, Secretary Valenzuela. From the PDEA,
To the Honorable Chairperson of the House Committee on Dangerous Drugs, Congressman Jonathan K.T. Flores, distinguished members of the committee, ladies and gentlemen, good morning. On behalf of the Philippine Drug Enforcement Agency, thank you for the opportunity to present our position and recommendations on the proposed amendments to Republic Act 9165, the Comprehensive Dangerous Drugs Act of 2002, as outlined in several House bills presented a while ago. For more than 2 decades, Republic Act 9165 has been the foundation of our national anti-drug efforts. However, the landscape of drug trafficking and abuse has evolved rapidly, and several provisions of the law no longer reflect current threats and operational realities. Today's drug networks operate as sophisticated, technology-enabled, and transnational enterprises. Syndicates now exploit social media platforms, encrypted messaging applications, e-commerce channels, digital payment systems, and even the dark web, giving them unprecedented anonymity, agility, and global reach. These advancements pose growing challenges to surveillance, investigation, intelligence gathering, digital forensics, and prosecution. In light of these developments, PDEA fully supports the urgent and comprehensive modernization of Republic Act 9165. We must strengthen provisions addressing cyber-facilitated drug crimes, enhance interagency information sharing and operational coordination, update evidentiary and procedural mechanisms, and ensure alignment with international standards for digital enforcement, border security, and rehabilitation systems. Thank you. We look forward to working closely with the committee in crafting responsible, forward-looking, and effective reforms of Republic Act 9165. If you will allow us to present the PDEA's anti-drug operations together with the other law enforcement agencies, our significant accomplishments only, sir.
For this year or for?
For this year, sir. And with corresponding comparison to the previous years.
Can you hold on to that? Because I would like to hear from the other resource persons
yes, sir.
first
Yes, sir.
regarding the 11 bills.
We will, sir.
Thank you. Thank you, Asek Gumban. May we now hear from the Philippine National Police on the comments on the 11 bills that have been filed.
Philippine National Police supports the foregoing legislative measures to amend RA 9165. The PNP recognizes that while the present law has provided necessary framework for the prevention and suppression of illegal drugs, emerging realities underscore the need for legislative reform. Mr. Chair, the PNP was able to submit our position paper with comments and recommendations for the consideration of the committee. Likewise, for the remaining presented House bills, we will submit our position paper. And the PNP expresses our continued commitment to contribute to our government's campaign of ending drug abuse and trafficking, uniting with PDEA and other law enforcement agencies to dismantle criminal drug syndicates. Thank you very much, Mr. Chair.
Thank you, General Manalad. We now hear from the National Bureau of Investigation. Sir, comments on the 11 bills that have been filed.
Thank you, Mr. Chairman. Okay. Sir, while we fully support all the proposed measures, there are some provisions of the proposed measures that need to be discussed further and thresh out in order to come up with a better approach. For instance, the numerous presumptions that were laid down in the proposed bills, they are very dangerous and counterproductive. Number one, it puts everyone, the Filipino people, it exposes every Filipinos to drug trafficking cases. And all the people who are supposed to protect them are also exposed to being charged with serious offenses. For instance, if a person is present in the place of drug sale, he automatically becomes liable for drug trafficking. And any law enforcement officer or prosecutor or judge, prosecutor and law enforcement officer failed or something like that, the case was dismissed or the accused was acquitted, there's a presumption automatically that there is an unsuccessful prosecution and he's going to jail for that. And that's something that needs to be discussed further because it will not encourage law enforcement officer or prosecutor to investigate drug cases. No, it's counterproductive. It will scare most of law enforcement officers to handle drug cases. No? Now, we agree that aliens are the penalty imposed for aliens are violative of the equal protection law. But most importantly, it's a selective approach on the drug traffickers. No? That it does not provide for a clear distinction between a Filipino drug trafficker and a foreigner drug trafficker. While it will encourage other aliens from trafficking drugs in the country, it will encourage others. No? So it's not really effective. No? If you want to discourage anyone from trafficking drugs, we're supposed to impose death penalty to all drug traffickers in the country. It's not supposed to be selective. Likewise, we agree that the penalty for committing drug cases in during calamities should be increased, but the 9165 already imposed maximum. No? It's already imposed maximum penalty. Most of it is life imprisonment to death. No? Except for use, which is you go to the hospital for treatment. Now, if you commit drug trafficking during calamities, when it becomes maximum, it will defeat the purpose of the rehabilitation process. So I think we should discuss and trash out all these provisions so that we can come up with a better approach of the anti-drug campaign of the government. And we already submitted our other observations, comments, and suggestions on all the proposed measures, Mr. Chairman.
Did the comments include these bills that have been introduced today?
Yes, Mr. Chairman.
We will go over your. Anyway, we'll be most likely be creating a technical working group. We will take into consideration your suggestions also.
Yes, thank you, Mr. Chairman.
Yusek Andres?
Yeah. Mr. Chair, just by way of supplement to the discussions on this matter, and also as representative of the National Prosecution Service as Undersecretary in charge, we just want to give our comment also on the provisions that include bungling of cases with prosecutors as an additional offense.
Before you proceed, Yusek Andres, has any prosecutor ever been charged for bungling?
I don't think so, Your Honor. Wala. And it's quite unusual where don't involved really in the prosecution of a case left to the court's appreciation. But to us, it is sufficient. It is now dependent on the court's appreciation of the probative value of evidence submitted.
I think the intention naman of the bill is to punish someone who intentionally
I think
bungles the prosecution,
meron
right?
pong pinanggagalingan yun, Mr. Chairman, dahil meron talagang ibang kaso
Ah.
that should not have been filed in the first place or was implemented without a warrant and purposely
Because I think the intention naman of the author is just to parang put it out there that in case someone intentionally bungles the prosecution of the case, then there is a corresponding penalty.
But we're saying
Correct,
that there are sufficient laws already covering the accountability of those who will do malfeasance or non-feasance.
So this will be a redundant.
This is a redundant, and as pointed out by our NBI colleague, it is a deterrent from people investigating. Maybe I don't want to be involved because
You might be accused of
in
bungling
all
the case.
good faith, I will still be charged of bungling.
Right. Thank you, sir, for your inputs.
Mr. Chair,
Go ahead, Congresswoman Luistro.
because I heard about the intention of the committee to refer this for the purpose of TWG, I wish to suggest, Mr. Chair, because considering that this has been approved during the last Congress, I'm not sure if whether it is up to the second or the third reading, but I remember clearly that we had a technical working group already approve the version of this bill during the 19th Congress. May I suggest, Mr. Chair, that we come up with a comparative report about the original provisions of that version from the 19th Congress and the new provisions as proposed by the committee on the 20th Congress. This is for expediency, Mr. Chair, in order to save the time that we have spent already during the 19th Congress when we approve the previous version.
The suggestion of Congresswoman Luistro will be duly noted. No? But we'd like to emphasize that the bills in the previous Congress were only approved on the committee level. But again, having the matrix would help us speed up the process of understanding the different bills that have been filed amending RA 9165.
Mr. Chair, if I may add,
Question of order, Mr. Chair.
Madam,
Are you now entertaining comments from the committee, or are you still going to ask questions?
I was actually going to ask other questions for other resource persons to speak, Madam Chair, but Madam Gloria, but some members of the House wanted to ask some questions. But I'm going to proceed after.
Are you going to give preference to the congressmen or congresswomen who want to give a comment before you go? If there are manifestations here, or will you finish the resource persons?
I am
think
willing.
of which one more is remaining?
Yes, Madam. I'm willing to entertain any member who would like to have any comments on the resource persons.
Then if you can entertain me, because I asked to be recognized since.
Yes, Madam. Please go ahead.
Okay, Mr. Chair, let me say that I agree with all the bills here except the bills that impose the death penalty. I would like to quote President Marcos himself, his own words, on his first birthday after becoming president. He said, as a practical matter, does the death penalty does it discourage people from committing heinous crimes? And I think the data, not only from the Philippines, but from other countries, shows that it doesn't. So that is President Marcos talking about the connection between the death penalty and heinous crimes. And he rightly quoted the studies all over the world. And then there is now this is not his quote anymore, but the reporter says, even when he was still campaigning for the presidential elections, Last March 19, Marcos said he did not think the death penalty was effective in curbing crime. And that, Mr. President, really reflects all the scientific findings we have all over the world. Second, I'd like to point out that what Undersecretary Andres said about this total review of how to address drug trafficking comes from the human rights, the UN removing the Philippines from the Human Rights Watch. I think if we go back to the death penalty, we will go back to the Human Rights Watch. So that's why all of the, and then I'd like to say another thing, that when there was an attempt to impose a death penalty in previous Congresses, I don't know which one, it was when Senate President Drilon was Senate President. He said, we cannot proceed to imposing the death penalty because we have signed the second optional, we have ratified the second optional protocol on the Convention on Human Rights. Now, Yusek Andres also referred to the Convention on Human Rights, of which we are a signatory, and the second optional protocol specifically prohibits the death penalty. And we are a signatory of that, and we have ratified that, and that is why the Senate, which is the ratifying body, never wanted to reverse a ratification. It's always been the conventional wisdom is that it is the enforcement that matters, as Jesse said, not the punishment. In fact, when we were having a debate on the death penalty, when I was still a senator, I cannot forget the statement, the very cryptic statement that Senator Sandy Osmeña made. He said, with a death penalty, poor boys fry and rich boys fly. So it is effective when you're dealing with the poor, but when you're dealing with the rich, for so much money to spend, then the possibility of conviction becomes lower. For those reasons, Mr. Chair, I would like to urge that instead of death penalty, when you're talking about a higher penalty, there is a higher penalty than life imprisonment. The higher penalty is life imprisonment without possibility of parole. And I would like to suggest that that be the higher penalty to be imposed in all of as a substitution for these provisions that are being proposed. And then lastly, now this is not related to the death penalty anymore, but to the dangerous drugs law. I was the president who signed the dangerous drugs law. And so I just want to share some experience of what what I think is the work undone yet, still undone. The dangerous drugs law provided that the enforcement against drugs should be transferred to a DEA, which we call the PDEA. In the same way that in the United States and other countries, drug enforcement is separate from the police force. So in the review of the law, I would like to go back to that proposal, give it a try, because when we passed that law, there was a provision. I don't know if it's in the law in the IRR that provides for a transition. That first the police will do the dangerous, the anti-drug enforcement, and until the PDEA is ready. So the thing is, though, as a practical matter, because the PNP was very, very effective after that dangerous drugs law was passed, especially under General Aglipay. First, he was deputy head of the police, but in charge of drug enforcement. And the raids that he conducted, the enforcement that he did was admirable. And then he became chief of the PNP. So I was very comfortable with that. So I didn't impose anymore. Oh, let's transfer it to the PDEA. But so many years have passed, and I wouldn't know how. I mean, it's not for me to judge how effective the PNP has been, but maybe it's also time to begin looking at how can we now really apply that provision if the review thinks that it is appropriate to begin transferring the job of drug enforcement to the PIDEA. Thank you, Mr. Chairman.
Thank you, Representative Arroyo. I think that's section 86, huh? Which, about the transfer of the functions of the drug units, abolishing the drug units of the PNP, NBI, and transferring it to PIDEA. And actually gives them a time frame. It's supposedly 18 months. But there's also a caveat there that says that if the personnel of PIDEA is already sufficient or something to take over the things. No? So I think these are questions that should be.
But we were not in a hurry to fulfill the condition because the PNP was doing a good job under General and now Governor Aguipa.
Okay, thank you. Yusek Andres?
Yeah, Mr. Chair, just to complete the direction being set by the President, not only on the punitive nature of the law, but in his State of the Nation address, the President emphasized that the campaign against illegal drugs continues, but it has taken a new phase. It is now geared towards community-based treatment, rehabilitation, education, and reintegration to curb drug dependence amongst our affected citizenry. And the main gist of the bill coming from the multi-stakeholder proposal is putting resources in these aspects of community-based rehabilitation and reintegration into society. This cannot be implemented without any resources institutionalized in the budget of the ADAC, Anti-Drug Abuse Councils. The present law merely states that there should be substantial funds used without earmarking a particular percentage. And to us, that is not effective institutionalizing of the budget. If there will be a particular, specific percentage of 5% coming from the income of the LGU, particularly dedicated and exclusively for rehabilitation programs, reintegration programs, then all of these promises will be realized.
Thank you, Yusek Andres. I'd like to acknowledge the presence of Representative Christopherson Yap of the 2nd District of Southern Leyte. And of course, Representative Laila De Lima of Party List ML.
If I may just continue my line of
Go
thoughts
ahead,
earlier, Mr. Chair, the
Thank you.
suggested matrix is also for the guidance of the new members whose participation we truly commend, no? Perhaps we can include the original provision, the version of the 19th Congress, and then the version of the 20th Congress. Thank you, Mr. Chair.
Thank you, Representative Luistro. I'd like now to continue from our resource persons from the DILG.
Good morning po, Mr. Chair. Good morning po, honorable members and the distinguished resource person po. The Department of Interior and Local Government wishes to express its full support for House Bill 910, which aims to formally establish the Anti-Drug Abuse Councils or ADACs in every LGU. Since this bill is a refiled measure from the past Congress, we reiterate our earlier support as it will help ensure the ADACs to continually function properly and consistently across all communities. We also support po House Bill 5468 proposed by Congressman Richard Gomez po, which requires LGUs with seaports to create their own K9 teams trained for anti-drug operations. This measure enhances interdiction efforts at key points of entry, complements national law enforcement operations, and provide LGUs with practical tools to detect and disrupt drug trafficking activities within their jurisdictions. Considering po that both measures reinforce the essential role of LGUs as frontliners in local security, public safety, and community-based drug prevention efforts, the department respectfully recommends the approval of both bills. Thank you po, Mr. Chair.
Thank you. From the DILG. Did you submit your position paper on that?
We will submit po official position paper po.
Yes,
Ah,
please.
sige po.
Can you include your comments on the suggestion of Yusek Andres about,
Sa 5% po.
yeah,
Yes po. Actually, we submitted a previous position, but the percentage na nabanggit po doon is at least 2%. Iba po sa, ano po, yung last year po, May 2024 po,
Right.
yung previous position. But, of course, we will submit, ano po.
pero
Ay,
what needs to be amended ba for that purpose? When you require an LGU to apportion a certain percentage of their budget to a particular function?
Yes po, we support po. Mas maganda,
No. What law should be amended? Is it local government code or ano?
ay, ito po, yung 9165 po. Kasi
9165.
section 51 po kasi, tama po si
Mandating the
Yusek Andres
LGUs
po.
to appropriate a certain
Masyado
amount.
pong vague yung substantial portion. Masyado, it may lead to different interpretation po.
Yeah, because substantial would mean differently from
Yes po.
any
It
LCE,
may
di
lead
ba?
to- yes po.
So, okay. Thank you.
Thank you po, Mr. Chair.
How about from our Bucor?
Good morning, Mr. Chair, Your Honors, and members of this committee. The Bureau of Corrections has already submitted a position paper, but I think it was for Bill number 74, 371, and 2546. But for the new laws, for the new bills that we just read, the Bureau of Corrections, fully support the proposed bills, especially for rehabilitation and reintegration. And we are compliant with the Department of Justice. Actually, in the Bureau of Corrections, we already put K9 units in order to deter the entrance of drugs, and we have been using new technologies such as body scanners to prevent visitors from carrying drugs inside. Thank you.
Thank you,
Mr. Chair.
Bucor. From the Department of Health?
Good morning, Mr. Chair, Honorables. The Department of Health acknowledges the intent of the proposed House bills primarily aimed to amending Republic Act Number 9165, otherwise known as the Comprehensive Dangerous Drugs Act of 2002, in the interest of strengthening drug prevention and control, while ensuring that interventions are just, proportionate, and responsive to public health priorities. The Department of Health recognizes the timeliness and importance of these proposed measures, noting that they provide an opportunity to align drug prevention and control policies with the public health and human rights-based approaches to substance use as mandated by the Mental Health Act of 2018, RA 11036. The integrations of evidence-based, compassionate, and community-oriented interventions is further consistent with the Philippine Council for Mental Health Strategic Plan 2024 to 2028, particularly in enhancing access to community-based services and addressing substance use as both a health and social development concern. These measures are also recommended to be harmonized with the Universal Healthcare Act of 2019, RA 11223, to ensure that treatment, rehabilitation, and reintegration services for persons with substance use conditions are fully integrated within the Comprehensive Health Service Delivery Network. In line with the Department of Health National Health Promotion Strategic Framework, the proposed amendments may emphasize health promotion, stigma reduction, and preventive education in schools, workplaces, and communities as essential elements of drug prevention and control. The official position of the Department of Health will be submitted through the signed position paper to be furnished to the committee. Thank you, Mr. Chair.
When will we have that position paper?
We have with us, sir, but ipapasahin na lang po na.
Sige po. Thank you. From the UP Institute of Human Rights?
Hello, good morning to everyone, especially to the honorable committee members. The UP Institute of Human Rights was brought into this effort to look into evidence that would support an executive review of RA 9165. And it was last year that the Drug Summit was organized, and the UP Institute of Human Rights presented the outcomes report of the inputs from several dialogues, which was about there were 12 sectors involved in the dialogues, spanning 10 regions, where there were 402 participants. And this is separate from those who participated in the National Drug Summit mismo, no? And then aside from that, we had several organizations submitting 27 position papers on the RA 9165 review. And some of the government agencies which submitted position papers were the Commission on Human Rights, the PNP Drug Enforcement Group, LGUs from the CDO and Antipolo, PIDEA, and the Supreme Court of the Philippines, and of course, non-governmental organizations, other academic and research institutions, as well as healthcare and rehabilitation centers submitted their position papers. Aside from these inputs, there was rigorous research on the alignment of this executive review with other laws, particularly the mental health law, the HIV/AIDS law, RA 9344 or the Juvenile Justice and Welfare Act, that 7610, which is the Act Against Child Abuse and Exploitation, the Magna Carta for Women, and the Universal Health Service Act. Of course, the review was also informed and guided by the constitutional standards, and particularly the human rights standards. So let me go into some of the comments on the bills. And as mentioned by the Department of Health resource person, drug dependence or substance use is already subject of the Universal Healthcare Law, as well as the Mental Healthcare Law, where we consider persons who use drugs as service users. So the reframing of the dangerous drugs law from a public health approach is no longer new. We can just align it and focus on the rights of persons, no, particularly the vulnerable groups. And after this research, further actions were undertaken to ensure comprehensiveness of the reform proposal. So we also came up with some suggestions on how to review and amend RA 9165. There's a proposed bill initially crafted by the UP Institute of Human Rights, and this was subjected to several deliberative workshops as well as 3 focus group discussions. So we will be submitting that as well for the information as well as appropriate action of the committee. So let me just give some inputs on the bills. And if we look at the several bills, of course, we always emphasize human rights. And we look at the differentiated impact of the different proposals on human rights, particularly equality and dignity of people. And at the same time, focuses on the rights of the vulnerable groups, like children and women. And the dialogues made sure that their voices are part of this law reform. Also, with respect to this rigorous research, we also took into account the disciplines, other disciplines like social sciences, psychology, and I think there was also a sociological report, and it looked into the context of persons who use drugs. So we also integrated that in the research. And we go for, of course, the public health approach, where we look at the social determinants why people use drugs. And one aspect that is critical is the addressing the issue of stigma, because based on the dialogues and the research, we found out that access to treatment and rehabilitation, medical services were not being done because of stigma. They refuse to go into these centers primarily of discrimination. And if we look at the proposal, we look into the continuum of care relating to public health services, so from community-based treatment and care, and then rehabilitation, but more on voluntary rehabilitation, depending on the different degrees of intensity of drug dependence or substance use. That would be all.
Thank you, Attorney Litang. From the UNODC.
Magandang umaga po, Mr. Chair and the members of the committee and the distinguished guests. So on a broader input po, we are one with the position of the DOJ, with the DOH and other members or other panel members in promoting a humane and a public health approach in addressing drug-related challenges in our communities, especially providing access to treatment to those who have been affected by drug use and dependence, including their families. Because not I think, but based on science, we must uphold a balanced approach to addressing these issues. Of course, not only on drug demand reduction, but strengthening the law enforcement efforts, meaning to say, addressing yung mga organized crimes, organized groups, organized criminal groups, and transnational organized crimes. So yun po, that's our position and our support to the bills that's presented in this committee, a more humane approach, which is based on science, because as we know, our existing 9165 is a more than 2-decade law already, and I think it's high time for us to review this law and update yung ating approach that aligns to the current situation and the current needs of our communities and our families. That would be all, Mr. Chair. Thank you.
Thank you, UNODC. Any members who would like to have or ask questions to our resource persons? Representative De Lima.
Yes, Mr. Chair, good morning, Chair and distinguished colleagues and our resource persons. I just have certain comments, short comments, and also few questions on certain bills. With respect to the bill, HB 4716, on the imposition of death penalty, I am in opposition to the imposition of death penalty incorporated in this bill. I'm afraid that we would be in violation of the second optional protocol to the ICCPR, which categorically states in Article 1 that no one within the jurisdiction of a state party to the present protocol shall be executed. So I think this warrants reconsideration. As to the other bills, I just have certain questions, clarificatory or otherwise. With respect to HB 910, an act creating anti-drug abuse councils in all provinces, cities, municipalities, and barangays. I'm sorry, it's supposed to be House Bill 918. An act mandating incineration facilities, including crematoriums, to render free services for the prompt destruction of dangerous drugs seized during anti-illegal drug operations and for other purposes. Ang may tanong lang po ako, will the requirement to render free services impair the regular commercial operations of crematoriums, particularly small operators? Pwede po ba nating i-consider din yan? I'm not saying that I'm opposing this bill. I'm not at this point opposing this. Gusto ko lang po malinaw sa sagot sa tanong na ito. Makakaapekto ho ba ito sa regular operations of crematoriums, particularly yung mga small operators, especially so na karamihan po sa kanila ay small operators? And my second question is, shouldn't this bill also consider other destruction technologies? Example, thermal decomposition, chemical neutralization that are safer or more environmentally sound technologies. So for consideration of the committee and of the authors for House Bill 921. It did not be answered now. I'm just presenting this for the consideration of the committee. Next po, yung tungkol sa House Bill 4710. How will the presumed knowledge standard, so yung House Bill 4710 is an act strengthening drug prevention and control, amending for the purpose Republic Act 9165 or the Comprehensive Dangerous Drugs Act as amended. Ang tanong ko lang po dito para malinaw, and this is more on the legal aspect also, nuances of the law and of certain legal principles. How will the presumed knowledge standard avoid criminalizing persons whose family or colleagues engage in drug activities without their knowledge? So that's one point. Number two, will AMLAC and PIDEA have clear joint protocols for freezing and forfeiting drug-linked assets? I'm all for the freezing of drug-linked assets, but we should have very clear and comprehensive protocols, especially interagency mechanisms, kasi doon po lagi nagkakaroon ng problema o mga loopholes. Again, for consideration of the committee. And shouldn't this bill also mandate, kasi parang hindi ko pa po nakikita on my perusal of the bill, shouldn't this bill mandate also body cameras or digital evidence for transparency? So I'm not sure if meron na pong pwedeng sumagot sa tanong na yan.
Thank
Noted
you,
for notation.
Representative De Lima. We will be taking note of you.
Opo, isa na lang po.
Go ahead po.
Yung House Bill 921, an act promoting the speedy disposition of drug cases by creating special court to be known as a dangerous drug court in every city and province nationwide. Basically, I'm in favor of this. Meron lang po akong dalawang tanong. Shouldn't the number of dangerous drug courts be based on case volume rather than a fixed one per city or one per province mandate? For consideration po. And the next question is, has the judiciary, the Supreme Court perhaps, provide a cost estimate for setting up these courts, including infrastructure, staff, security, and digital systems, para we can determine the overall reasonableness of this proposal, although basically we are for that. Pero yun na nga po, lalo na po dun sa unang tanong ko po, di ho ba mas practical ang based on case volume? Kasi baka naman may mga ilan-ilan tayo mga munisipyo na konti lang naman ang mga drug cases. And pwedeng i-focus na lang doon sa isang munisipyo, sa isang distrito, na magkalalapit lang naman, and doon na lang i-create yung drugs courts. for consideration again of the committee. Maraming salamat po.
Thank you, Representative De Lima. We will also ask the Supreme Court to make a comment on this proposed bill during the establishment of drug courts. Do they have a comment already? Sir? Is that address?
Yes, Mr. Chairman, if we will be allowed also to give our inputs on the matters raised by Congresswoman De
De
Lima.
Lima. Go ahead, first.
We joined the good representative on her insights on the death penalty. It is absolutely in violation of the second optional protocol. And for us to adopt that as a law would be going backwards instead of compliance with our international commitments. Likewise, we have raised this as part of the DOJ that there are certain legal presumptions in the proposed law that are too onerous and violative of the constitutional presumption to innocence. And it would really be counterproductive if we integrate all of these presumptions, because we will not be able to effectively implement the law with all of these presumptions. And there will be so much collateral damage unintended. And we are in agreement with that observation. On the body cameras and use of digital evidence, it is best to be integrated in the law. But again, to me, this is an operational matter that can be left to PIDEA. Because in our experience, the integration of mandatory procedures in the law, including the chain of custody rules, sometimes stands as an obstacle in prosecution because the accused may raise all of these technicalities or non-compliance with particular procedures as a defense. And we are not able to effectively prosecute the guilty because of the technical requirements as stated in the law. That's why we were also moving with respect to the witnesses on the inventory of drugs, that we already removed the media, we already removed the members of the National Prosecution Service, because oftentimes the strict compliance with these procedures become our Waterloo in the prosecution of cases. On the creation of special courts, there are already existing special courts, but our latest discussions with the Supreme Court says that it would be best to allow all regional trial courts which exercise general jurisdiction over cases to take cognizance of all drug cases, because this will take into account the availability of the courts in those particular areas. Although there is wisdom in the fact of assigning special courts based on the volume of cases, we'd like to inform the body that based on our new statistics, which we presented earlier today, there are less cases being filed in court now because of the higher threshold in the DOJ reforms, where we are now institutionalizing not probable cause as the measure, but reasonable certainty of conviction based on prima facie evidence at the hands of the law enforcement agents and the prosecutors. So right now, compared to last year, there were 70,000 plus cases. Now there's 35,000 cases filed only, but 93.9% conviction rate.
Mr. Chair, just a brief retort
Go ahead,
on two issues.
Congresswoman De Lima.
Just a brief retort. The proposed removal of the National Prosecution Service representative, I was actually, nakalimutan ko lang po kanina, itanong yung point na how would the removal of the National Prosecution Service representatives, the anti-drug operations without compromising the integrity of evidence. And then could the removal also of the NPS representative increase the risk of challenges to the evidence's validity? And how does the bill propose to mitigate such legal risks? Doon naman po sa punto about yung body camera. I agree that indeed it's more of an operational matter na yung sa PIDEA po and PNP ang dapat ang mag-address niyan. But it should still be ideal na meron hong mga ganyan na mga requirement. So ang lilinawin na lang po natin, and to make it firmer, ay yung how is it going to be presented in the bill, a provision that will ensure that when it comes to the implementation ay maging less prone to to operational risks na makakaapekto sa evidentiary integrity later, na hindi masyadong mahihirapan yung mga prosecutors ng DOJ. Thank you very much.
Thank you, Congresswoman De Lima. Yusek Andres, you want to answer something?
Yeah, okay. Just for additional input, earlier we also gave our conformity to the removal of the media people as possible witnesses in the inventory taking. But that doesn't mean that with the removal of the NPS or the media, there will be no other person who could possibly validate. It can be a broad description. Any public official can add transparency to the inventory taking and marking of evidence, not necessarily media, not necessarily a member of the NPS. That's all, Mr. Chairman.
Thank you, Yusek Andres. Didn't PDEA, in one of your briefings, mention the fact that you also have an issue with body cameras? Lalo na sa mga buy-bust operations ba yun or something? Kayo ba yun or si PNP ang may sabi niyan?
We have no issue with our camera, sir, but I don't know about
I think
other
it makes it more difficult for them to parang buy-bust ba yun or something? Kasi
yes, sir,
nakikita
we
yung
use-
body camera or something.
Yes, sir. We use the body camera during service of warrant of arrest
Yes.
and only for search warrants,
Yes, but not for
not for other purposes.
other
Because that-
purposes.
that's
Because it's so
mandated by the
difficult to
Supreme Court.
conceal it, correct? Di ba? Mahirap itago eh.
Yes, sir.
You cannot pretend to be a buyer and having a body camera at the same time, di ba?
Yes, sir.
No one would believe you'd be an innocent buyer or something.
The one the one with the camera is far away now.
Far away.
Just-
Not the one
just
who's
to
actually
observe.
dealing with
No, sir.
with the pusher, correct?
No, sir.
Because it's, nga, mahirap itago, di ba?
Yes, sir.
Alright, sige. Thank you. PNP, do you have the same issue ba?
Likewise, sir, Mr. Chair, we are agree with the PDEA that using body-worn camera is not practicable during buy-bust operations.
For service of warrants, etc.,
Yes.
it's okay to have
For
it.
other operations, sir, we
Right.
have our POP, but for this purpose, sir, for buy-bust operations, sir, it's not practicable.
Okay, thank you. Any other member?
Chairman?
Yes,
I wonder why the body cameras are not allowed during operation and drug buy-bust operations. Is that a SOP that we don't use anymore? Body cam? Because that is basically a police operation. Okay? I want to know what's the rationale? I don't use cam cameras. I mean, body cameras, I mean.
Mr. Chair, I would like our operating unit, the PDEG, to answer the question.
Colonel Laming.
Mr. Chair, sir, based on our experiences, using body cameras would compromise our operations.
Can you expound on that, sir? Why would it?
Yes, sir. As based on the rules on body worn cameras, it recognizes the peculiarities of the buy-bust operations, and that is provided in our qualifications. So, under Section 3, the use of body-worn camera during arrest, where a peace officer effectuates an arrest under Section 5, Rule 113 of the revised Rules of Criminal Procedure, and so far as it is practicable. So the arrest shall be recorded using body-worn cameras or alternative recording devices in the same manner as an arrest made with a warrant. So the same as said by General Manalad, it is not really practicable during buy-bust operations.
General?
Yes, sir. By bust operation is a means to arrest a person. So if it is during the process, sir, medyo mahirapan kami. Hindi siya practicable. Masyado siyang nakikita. Yung mga body-worn cameras namin, malaki yun, sir. We have used it in several, when I was with the other unit, for trafficking in person. So pwede siya, sir. During the process, inaaresto na namin and nag-serve kami ng warrant of arrest. But for purposes of by bust operation, which is means to find out and arrest the person during the process, medyo hindi siya practicable, sir.
Okay.
Congressman Rodriguez?
I really,
Ano lang
I
po?
really object to that, because the main objective is to really to get to the bottom of the operation, no? And pictures or videos don't lie at all. So maybe on the segment of human rights that be another angle, but it's really quite amusing. It's really quite shocking to know that we don't use that at all, when in fact it's a source of evidence. I would submit to the legal.
Mr. Chair, naiintindihan po natin yung sa aresto, kasi mag-aaresto nga. Di ho ba? Sa buy bust, wala ba yung mga other gadgets? Similar gadgets that can document the whole activity. Wala ba kayong sa mga nakikita natin sa mga Netflix? Wala tayong mga ganon hidden gadgets, recording gadgets, recording conversations. Kasi syempre ito naman talaga, this is stupidity if you use this sa buy bust. Of course. Alam natin yon. But we are actually referring to other modes na marirecord. Ang punto lang naman is marirecord what is happening so that we know that everything is being done within legal processes na walang mga violations of human rights. Kasi yun ang mga nagiging excesses dati sa mga ganyang mga operations. Correct?
Yes, ma'am. We'll consider other alternative
Yes.
devices. Yes,
If
sir.
I may suggest, Mr. Chair, that they submit their written thoughts on the matter.
General Manalad?
Mr. Chair, ma'am, we will submit the necessary papers.
Thank you.
Mr. Chair, may we know from PIDEA and the NBI regarding your practice on the supposed requirement of body cam during drug operation. Kayo po ba ay medyo naglaylo na rin on this requirement, considering that it's too obvious, those cameras that were shown by the DOJ?
Yes, Your Honor. Ideally, dapat may ganon, no? But it's impractical nga, no? Because of the bulky siya eh. But we should also consider that it's too dangerous. Usually naman hindi ideal yung situation where you conduct buy bust. And these drug traffickers know exactly yung trade nila eh. Kakapkapan ka niyan, titignan ka kung meron kang ganon. And once they discover that you're an undercover, you're gonna be shot, man. So rather than putting someone in danger, it's safer for an undercover operative. Kasi helpless siya at that moment. Eh. Hindi niya kayang i-defend yung sarili niya right there and then. If we're going to put a camera on the person and it's discovered, it's not gonna be good for that undercover operative.
May we hear from PIDEA, Mr. Chair?
Ma'am, we are not using the camera for the posture buyer. Because posture buyer is the one contacting the buyer.
Yeah.
But at a distance, we are using the body camera from the start of the operations. When arrested, the body camera will go near to the arrested persons and inform the rights for transparency that there is no human rights violation.
I recall some cases which were dismissed because of irregularity in the use of body cam. And now I'm surprised to hear it from the law enforcement agency that you have relaxed in the implementation of this body cam rule. So perhaps, Mr. Chair, we should address this also in the amendment of the dangerous drugs law, because our law cannot be unstable. If we have an existing law, our only option is to implement, and there is no other option.
Yeah, we will take that into consideration when we form the TWG. Yes. Any other member?
Mr.
Yeah,
Chair.
go ahead, Congressman Santos.
Anyway, Mr. Chair, just a manifestation regarding the post-arrest protocol of the different agencies. May I suggest, Mr. Chair, that during the inventory of drugs, siguro mas maganda, Mr. Chair, yung on-site, yung certificate of inventory, pati yung chain of custody form during the buy-bust operation, and likewise secure seized items in a tamper-proof evidence bag with markings, consent, and all documents. Siguro, a while ago, we were talking about the body cameras. Well, the different agencies are talking about experiences. Siguro, sa totoo lang po, nung nakita niyo yung body cameras, napakilaki po pala. At talagang sunog na sunog ang mga ahente. At siguro nakasalalay din kasi yung buhay ng mga operatiba natin. But with regards to the proposal of some members of this committee, siguro we can find some ways and means para marami naman ngayong high-tech na technology. And then the issue of sa dismissed cases natin regarding doon sa mga body cameras. Siguro the committee will request the different agencies to submit proposals po for the committee's action po. So that's all, Mr. Chair. Thank you very much po.
Thank you, Congressman Santos. Any other member?
Mr. Chair,
Congressman Rehencia?
I move to constitute a technical working group to be headed by the chairman himself because he is a lawyer to consolidate the measures and submit a substitute bill on the matter not later than February of 2026. So move, Mr. Chair.
Second, Mr. Chair.
There's a motion to create a technical working group and to submit the report when?
Not later than February of 2026, Mr. Chair.
Okay. Any objection? There being none, then we will create a technical working group to tackle all the 11 bills and the other bills that were filed earlier for the amendment of RA 9165. Yeah. Sir, Yusek Andres?
Just to give the body some idea on what we will submit to the technical working group, let me just state the topics which were the subject of the drug summit and for which we are submitting the observations and insights of the multi-stakeholder group. This include the promotion of scientific, evidence-based prevention and treatment programs. The stakeholders have shown that a one-size-fits-all approach is wrong, and all of the treatment programs should be tailor-made to particular persons involved in drug dependence, depending on the severity of their dependence, whether it is just mild, moderate, or severe. Now, next aspect is access to services. While we keep on saying that we are providing rehabilitation programs, access to these services is very quite limited and nugatory in certain areas. That is why the need for specific budget in each ADAC or in each LGU should be mandated and not just a general provision in the existing law which says substantial portion. Now, next is the public health approach, which understands that the dependence of an individual is not only a matter of law enforcement, drug dependence is not a matter of law enforcement issue, but also a medical, physiological matter that should be addressed with psychiatric, mental health, and medical interventions. Next is rehabilitation as a health treatment should be tailor-fit, and that relapse, this is one observation that we were decalled from the multi-stakeholder discussion. It is not failure for the rehabilitation program if some of the patients have a relapse. It is their observation that indeed a certain percentage will be treated, but there will still be a percentage that will fall into relapse. And it is not a failure, but there should be post-treatment facilities to address relapse. Now, on drug testing and screening, this is also a matter that was raised with respect to human rights, and that mandatory drug testing should not be allowed. And as sustained by the Supreme Court, only random drug testing for particular purposes can be allowed, but not a blanket mandatory drug testing, even for candidates for public office. Now, focus on major offenders. This is another insight called from the major stakeholders discussion. We should have a program to address supply reduction involving major drug trafficking suppliers, and not just focus on the low offenders who are just users, who should be put into rehabilitation depending on their severity and not necessarily incarcerated, because there are instances of mild affliction that can be treated on an outpatient basis, not necessarily mandatorily confined in a drug rehab center. Now, support for reintegration, that is why it's very important that the rehabilitation be done in the community level, because the social support group is very much needed in reintegrating people back into society after they have been exposed to drug dependence. The last three are destigmatization and non-discrimination. We should understand this as a public health issue, and there should not be any stigma for an individual seeking assistance for treatment as a drug dependent. And finally, protection of human rights, that there should be mechanisms, as being pointed out now, to assure that operations, drug operations, are fully compliant with the constitutional dictates on the protection of human rights. And aspects of harm reduction also came out in the discussions, meaning alternatives to incarceration should be considered. It is not always that punitive measures will solve the problem, but more restorative and rehabilitative programs should be institutionalized, and instead of putting people in jail as the major approach to drug control. That's all, Mr. Chairman.
Congressman Santos?
Mr. Chair, if I may add, I would just like to ask a question address the question to you, Sec. Andres, regarding the post-arrest protocol. Because during the time of Secretary Boying Remulla, nagkaroon po kayo ng programa regarding the coordination between the PNP and the prosecution service para yung build-up ng cases po is matibay. We'd just like to ask during the post-arrest protocol kung meron pong representative na doon sa site para yung cases po mas maganda. May mga fiscal...
NPS ba?
Yes,
No.
they practice this in the developed countries like sa United States. Siguro napapanood natin sa TV yung mga district attorney sa Amerika. Nandun sila sa crime scene. And parang doon papunta yung programa nyo, USEC, nung araw. So ito ba ay kaya ba ng manpower ng NPS to na magpadala ng mga prosecutors na on the crime scene? No? Thank you, Mr. Chair.
Well,
Yusek Andres?
just to inform the body on the legal framework, based on our department circular 20 on the case build-up policy, the law enforcement agents are given access to the prosecutors 24/7 whenever there are actual operations. And our prosecutors, whenever practicable, should assist them in the actual operations without being involved in the actual by bus operation, but to guide them on the proper procedure and the constitutional requirements to be observed in the exercise of the by bus operations. And although it is also a challenge with respect to the number of prosecutors available, it is a logistical question. But the legal framework is there to assure the cooperation between the law enforcement agents and the prosecutors to ensure effective investigation and prosecution.
Mr. Chair, malaking bagay po yan at it's good to hear from Yusek Andres yung balita na yan. So, we just, my manifestation also, Mr. Chair, to sponsor this amendment. Mr. Chair.
To
Thank you.
cooperate?
Yes, please. Thank you.
I think to add, no, which I think Yusek Andres should emphasize the fact that it has led to a 93 point something % conviction rate, diba? Kasi that's what's important eh. I think other than the fact na mataas na yung penalties, it's more of the certainty of conviction ang importante dito eh. Para mas matakot yung tao rather
Sir.
than the penalty itself.
Sir, if you want some data on the incarceration rate from the Bucor, actually 65%, I'm sorry, BJMP, no?
Right, sir.
65% of cases filed relating to this, in all cases are drug-related. So napakalaki pa rin po ng percentage, 65%. At yung congestion rate, dahil po less cases ang fina-file natin, we undergo case build-up, bumaba na ho from 386% in 2021 to 286%. Congested pa rin po, pero 100% po nag-decline.
Pero ano naman, no, yung mga hindi na file, it doesn't mean na it's not no longer being pursued, correct?
Yes.
It's just that you don't have enough yet to assure the conviction.
We continue to build up the case, and whenever it is ripe for trial, that's the only time we file it.
Okay. Good to know. Yusek Andres, no? Okay ka na? Yeah, go ahead.
Mr. Chair,
Congressman
Mo-
Rehencio.
move to adjourn the meeting.
Second, Mr. Chair.
I'd like to thank everyone for coming. The meeting is adjourned. Thank you.
Chair and guests,